This is immigration attorney Peter Loblack from Peter Loblack Law Firm. It is Saturday, the 19th of August, and I'm going to discuss with you today asylum. I get a lot of questions from asylum on my page, and a lot of people come to my office to talk about asylum. I've represented a number of individuals in asylum matters all the way to federal appeals court. And I find that a lot of individuals, especially foreign nationals, do not understand the concepts of asylum. First, in order to apply for asylum, you have to be in the United States. It's different than it's different from you being in your country and you're a refugee. There's a separate process for individuals outside the country who are refugees. So when we talk about asylum, we're talking about individuals on U.S. territory applying for asylum. Now, why does one apply for asylum? And the definition in U.S. law and asylum law is clear. Now, the individual is afraid to go back home because of past persecution or a well-founded fear of persecution if the person is forced to return home. The persecution have to be on account of race, religion, national origin, or membership in a particular social group. Now, individuals are afraid to go back home because there are criminal activity at home. Criminal activity in and of itself is not grounds for asylum. No one gets asylum because your country or your city or your neighborhood have crime. That's not the purpose. It is based on persecution. Now, who are the persecutors? And persecution does not necessarily have to come from everyone. It has to be either persecution by government officials or individuals or group in your country that the government is unable or unwilling to protect and control. So if you are being persecuted by police officers, they would be deemed officials of the government, military officials, high government officials. All of those could be deemed agents of the government. Now, remember, it have to be the persecution that you're suffering have to be based on your race, your political opinion, and also membership in a particular social group, or based on your religion. So if someone is persecuting you because they want to maybe take your land, there's a family dispute between neighbors, these are not going to be grounds for asylum in the United States. So it's always important when you enter the United States, and people travel all over the world, they come through Mexico, etc. They may have traveled on fraudulent documents and they arrive at the airport, and then they're going to ask for asylum. I am afraid to go back home. If you're applying for asylum, if you're requesting asylum, it is always best to do so immediately upon arrival, especially if you travel to the U.S. with fraudulent documents. It could be at the Mexican border, the Canadian border, or at the airport. You should declare that I am requesting asylum. If you don't, then you may have some issues later on. But one other date you need to understand. If you happen to make it into the United States and you're afraid to go back home, you have 1 year from your arrival, 1 year from your arrival to apply for asylum. If you apply for asylum later, then you're going to have issues. You may not really be applying for asylum. There are other related relief grounds that you could seek, but that's in the same asylum application, and that is withholding or deferral, but we'll address those a little later. I want to concentrate solely on asylum. There's clear grounds for asylum. So when you apply for asylum, you will be given a form, a 589, that you need to complete. It is absolutely crucial that you take your time in preparing that application. It is maybe more important to retain an immigration attorney to help you prepare the application and to provide the necessary affidavit to support that application. You may need supporting documents to document your persecution. The more documents you have, the better. Sometimes you may not have documents. It may be difficult to get documents, and all that. It may be okay. It is going to depend on the specific facts of your case, what's going on in your country, how you fled your country, etc. So, but the crux of the matter is the application and every affidavit must be carefully completed. Now, initially, you will be detained. A lot of individuals coming into the country applying for asylum will be detained. You may be detained for a couple of days, or it could be for months, or until your asylum application is decided. And there are processes that one needs to go through. So, after the application is filed, you most likely will be interviewed by an asylum officer from the asylum office. This is a separate office within the Department of Homeland Security that deals with asylum. At that interview, you have a right to be represented by a lawyer or have your lawyer present to assist you in answering the questions and to explain your situation. If you do not speak English, an interpreter will be provided for you. The government does provide interpreters for individuals. If you have any document in foreign language, we need to translate those into English. You'll be interviewed. It will be an extensive and probing interview about your life, your family. Everything that's on the application will be reviewed. And they will probe as to how you left your country, what happened, and you need to be as specific as possible. Consistency is important because as you go down the line, any major variation in your story or could lead to a denial because it goes to your credibility. Credibility is absolutely important in asylum to make sure that the individuals who are applying for asylum, they are generally genuine individuals. They actually suffer real harm in their country and they are seeking relief today. So it's absolutely important for consistency and to be detailed as possible. Now, let's say you cover all of those. The asylum officer will have an opportunity to review your statement, review your application, consider any documents that you attach, and a decision will be given. And this interview is generally called a credible fear interview, to see if your fear is really credible. Is it based on past persecution? And what evidence of the past persecution that you have? Why are you afraid to go back home? Could you move to a different part of your country and be okay? Would the individuals pursuing you find out that you're in the country somewhere, maybe in a different city, a different location, and come after you? These are essential consideration in asylum. So a decision is rendered. If there's a credible fear determination, the officer determined that yes, we believe that there's fear, you have a credible fear of persecution if you return home. They may grant you asylum if they look at the persecution as being real. So the asylum officer could determine in your specific case whether to grant asylum. If you're granted asylum, most likely you'll be released. And later on, you'll get the documentation because there's a certain amount of asylum application per year, depending on how the backlog works. You'll be released and maybe issued a decision for which you could obtain a work permit. But let's say your case is pending and 6 months has passed. After 6 months has passed, you could apply for a work permit. Many individuals will be detained. So you may be detained at various detention centers. One of those is Folkson in Georgia, and you may have to go through the process internally. If it's your asylum application is denied by the asylum officer, or they didn't find there's a well-founded fear of persecution, you will be placed in what we call removal. That means you will be in removal proceeding. Immigration is going to charge you with trying to enter the country and appearing to enter the country without the proper documentation. For example, you came into the border, you had no US visa, or anything authorizing you to enter the country, so they'll place you in removal. That means you are in deportation proceedings. You will have to go before an immigration judge. The immigration judge, at the appropriate time, and again, I'm saying you should have a lawyer, your application for asylum could be renewed before the immigration judge. And then you'll go through the entire process before the immigration judge. And the immigration judge has the authority to either grant you asylum, or to order you deported, or to grant you whatever relief that you may have under immigration law. So it is absolutely important to have a lawyer. Consistency throughout in your story is absolutely important. And one should always understand that whatever you say, you're saying it under oath. And you're swearing to tell the truth and the whole truth. And there are certain penalties. There are penalties for frivolous application for asylum. If you file an application for asylum that the immigration judge or the asylum office determine was frivolous, or you later recant your story, you are not eligible for any other form of immigration relief. So it's important to understand that. It is important to take this thing seriously when you apply. Running away from criminal activities, or the fact that you cannot obtain a job in your country, you cannot provide for your family because you do not have the education, or you don't have employment, etc., will not be grounds for asylum. Your application will be denied. I say it, and I say it strongly. Have proper immigration representation. The immigration lawyer will be present with you, will accompany you at any of your proceedings, will be in the room with you, will assist you during the process, and before the immigration court, will be your main advocate and representative. Because the government is going to have a lawyer in immigration court. That lawyer purpose is to have your application for asylum denied and to have an order of deportation against you. Now, I get a couple questions that individuals ask me. And one of the questions is, if you are detained by immigration and you apply for asylum or what, how could you get representation? Generally, if you are detained by immigration, USCIS generally do not detain individuals. They may refer you to their sister agency, ICE, which is Immigration and Customs Enforcement. They handle the detention, and they detain you. They could detain you at a jail if you're in Orlando, Orange County Jail, or any of the detention center. You will always be given a list and notified that you have a right to be represented by a lawyer. So you are free to contact any lawyer that you want to represent you. Individuals call my office. We represent a number of individuals who are detained. I would personally go to see you, or someone else in my office, another attorney in my office, would visit you and try to understand your case. If you're detained in a jail or at a detention center, we go in there. We discuss in private with you your situation, and the jails do provide interview rooms where your attorney could come in and talk to you. This is the U.S. You have a right to counsel, and your counsel need to be able to talk to you and assist you in the preparation of your case. Whatever you say to your lawyer cannot be used against you. I know a lot of the detention center, practically all the detention centers, all calls are recorded. Your attorney will always state when you call your attorney that this is an attorney-client conversation. So if they're recording it, they would either stop it or they would try to skip that recording. But if you're detained, you have access to telephones at the detention center, and you could call us. Your family member could always call my office. My office number is 407-295-0099. and then we will try to come to see you, talk to you, because most times your family member do not understand your case totally. They may have bits and a little piece of information. And so we like to go in and we like to talk to you personally at the detention center and try to understand your situation. Now, we cannot disclose what you tell us to your family member, but except if you give us, authority to do it. I tend to protect individual rights. It's an attorney-client privilege that you have, and and we are sworn to confidentiality in terms of not disclosing information you provide to us. So whatever you say to me, and many individuals may tell me stories that the family do not know about, but I cannot disclose those if they do not give me authority to disclose the information. But you could call our office and we'd be happy to listen to you and to talk to you and go to see you and see what we could do with your case. We try to be as honest and open and transparent as possible. We will tell you what we're going to need in order to effectively represent you. We will try to get as much documents for you in order to document your case, because most of the matters before immigration require documentation. Asylum, the more documentation you have in asylum to document your persecution, document your fear. We use the standard, there's a standard document we use in immigration court or before USCIS for asylum, and that is a country report. The U.S. State Department put out human rights reports on most countries, and we use those in order to document the case, in order to show, yes, that country is not good at protecting individual rights, etc. So we have resources to help you prove your case, asylum case, or just regular immigration case, whether you're applying for a green card, etc. One thing you need to understand, if you're granted asylum, 1 year after the grant of asylum, you could apply for a permanent resident card. So you become a legal permanent resident, and it's always dated a year back. So if you get a green card based on asylum, generally within 4 years or so, you could apply for citizenship. Now, if you have any kids with minor kids and you're granted asylum, the kids could apply for asylum as derivative. If you're married, your spouse could also apply as derivative. If they're not in the country, they would be permitted to come to the country. The only thing is that they need to be less than 21 if you have kids, and your spouse, you need to be in a bona fide marriage. And those are the requirements as it relates to asylum. If you're in the U.S., you have a year to do it. Apply for asylum a year from your entry into the U.S. Anything after a year, you're not applying for asylum, it would be deemed a withholding application for withholding of removal. Because if you apply for asylum a year after, and we cannot justify why you apply late, then it may be only a withholding to withhold your deportation. You will be placed in removal, generally, and you would apply for withholding of removal. You may be able to prove withholding, but withholding does not give you a green card. It just prevents them from deporting you at this time. Now, individuals, and majority of individuals at Folkestone are detained, have their immigration court hearing in Orlando. Folkestone is in southern Georgia, close to Jacksonville. It's a detention center. Most individuals who come in through Mexico applying for asylum are sent over to Folkestone. Individuals, their immigration court cases are heard in Orlando. They appear by video conferencing. They will be in Georgia in a room, and they will appear in Orlando Immigration Court through televideos. So your lawyer most times will be in court with the immigration judge, with the trial counsel for ICE. You will be at the facility, and that's how we do those hearings. If you retain a lawyer, your lawyer generally will just go to Orlando Immigration Court at the appointed time. When they call your case, you will be on the video. The judge will ask you, is this individual your lawyer? Is the person authorized to talk for you? If you have retained the person, obviously, the person appearing for you, it would be your lawyer. But that's the process. I have an office in Orlando, so I'm in Orlando. We handle those matters for individuals who detain at Folkestone, because Orlando is the immigration court for individuals here. I have a question that I'm going to read from Tosin. Say, I have a friend in the U.S., came in from Nigeria and filed for asylum 3 years ago. He already has a work permit and social security number. He got a letter last week for removal proceeding and gave him 30 days to appeal. What's going to happen to him? Well, let me tell you what happened. The individual came in, the individual applied for asylum. So generally you come in and you apply for asylum. The asylum officer will, as I said before, go through, give you a credible fear interview. Asylum officer make a determination. If they do not grant you asylum, they place you in removal proceeding, deportation proceedings before an immigration judge. Now, once you apply for asylum, if the asylum is pending for more than 6 months, you could apply for a work permit because they allow you to work in the U.S. That a work permit is not immigration status, so to speak, that you could stay. It's not a legal residency. You have a temporary authorization for work. So you work. A social security, you get that social security because you have authorization to work. It is not a legal status document. Social security number does not provide you with any legal status, just as a work permit is temporary. So the individual got that after 6 months, they apply and they have the work permit. That have nothing to do with the underlying asylum case. So the asylum officer may have denied the case. The individual is before the immigration judge. They went through all the process before the immigration judge, reapply for asylum. Maybe the immigration judge most likely deny the asylum. Once the immigration judge denies your asylum application, you're ordered deported, and he entered order of removal against you, saying that you should be deported. You have 30 days to appeal that immigration judge hearing to the BIA. And you should have a lawyer. I would hope that the individual had a lawyer before the immigration court. If the person did not, the person need a lawyer to file an appeal before the Board of Immigration Appeal. What's going to happen in an appeal? That individual is not going back before a judge. That case, the Board of Immigration Appeal is based in Virginia, in the suburb of Washington, D.C., and it's going to be based on written documentation. The lawyer must argue why the immigration judge was wrong. So it's going to be based on the transcript. Everything that transpired before the immigration judge is going to be transcribed. It's going to be documented, so you have a written hard copy of it. Your lawyer is going to comb through it and then formulate arguments as to why, read the immigration judge decision, and make a determination, an argument based on the law why the immigration judge was wrong. Maybe he misinterpreted the law, maybe he found the individual not credible and he based the lack of credibility maybe on matters that are not, when you look at them clearly, may not be an inconsistent statement. It could be based on the question that was asked and answered. Maybe it's based on misapprehension. But the lawyer have to comb through that transcript and formulate arguments to do that appeal so that the appeals court could review, and they're going to have a response brief also from the government saying, no, the immigration judge was correct in his or her determination and that this appeal should be dismissed. You saying the appeal should be sustained and a decision will be made. So that's the situation on appeal. The individual need to have a lawyer. Most layperson is not going to be able to formulate a proper appeal. Now, individuals, sometimes in a deportation, they may have applied for asylum upon entry, and sometimes they were paroled into the country, so they give parole. Remember, when you come into the country, you may not have a visa. Most individuals come across the Mexican border, they show up at the border crossing, say, I want to apply for asylum, I'm afraid to go back home. The officer, okay, we'll take you in. They may parole you into the country, but in that instance anyway, once you come in, you're what we call an arriving alien. If you're an arriving alien at the border and you were taken into the country and you happen to marry a U.S. citizen, you could apply for adjustment of status even though there's a deportation order. You need a lawyer again, I'm going to say. You're going to need an immigration lawyer. But you could apply for adjustment of status. But again, if you had applied for asylum and there's a your asylum may be denied initially by the immigration judge. If the immigration judge make a determination that your asylum application was a frivolous asylum application, you could marry to a U.S. citizen, you're not going to be able to adjust your status. So everything going to ride on what transpired in the asylum proceedings. So one have to consider that. If you happen to be married, if there's no frivolous finding by the immigration judge or the asylum officer, then you may be able to adjust your status. If your marriage is bona fide, everything has to go back on the bona fides of the marriage also. So your asylum application had to be genuine. Maybe you didn't have enough documentation to prove your case. Maybe there was some variation and they found you not credible, but there was no frivolous application. And you're married to a U.S. citizen, you have an option to adjust your status. If you're able to adjust your status, the immigration judge determination order of deportation could be reopened and then closed so that you have a green card. So it all depends. I would say contact my office. You could call my office at 407-295-0099 and let us look at it, or contact an immigration lawyer of your choice. But you should in that particular situation. Now, they say, what is a catch and release and what are sanctuary cities? Sanctuary, I addressed the last question, sanctuary cities. There are cities in the United States that do not permit immigration to come into their jails, for example, and detain individuals who are not citizens. Or they may issue detainers and they may not honor the detainers. For example, if you're a foreigner, you happen to have a traffic infraction in the U.S. You're driving, let's say, you're in San Francisco, California. And so the police came in, you do not have a driver's license, or you say you're driving on an international license and your arrival in the U.S. is more than 30 days. So you could be detained. In most jurisdictions, for driving without a valid license, you could at least be detained, be jailed, bring into jail, taken into custody, because the police officer want to know your identity. Your license is not valid. We do not know whether there are any warrants against you, so they may want to bring you in. So they bring you in. Generally, when most foreigners, if you have on the documentation you're not a citizen of the United States, you should never lie and say you're a citizen now. That's going to create some major problems for you later on. So you're not a citizen, then generally an officer from ICE, Immigration and Customs Enforcement, will come in to talk to you. So when they come to talk to you, they see, okay, you have, they look at your record, they talk to you, they see you're not a citizen, and that you have no legal permanent residence, the time for you authorized for you to stay in the country has expired. So what they'll do, they'll place a detainer on you. That means they tell the jail, before you release this individual, the individual may have bond because of the infraction, but before you release this individual, you need to give us at least 48 hours notice, which is 48 hours, and that's business hours, does not include the weekend, notice, so that we could make a determination whether to pick you up or not. So there are cities that may not honor that detainer. They may just release you if you post the bond, or if your underlying traffic infraction, if that's a traffic case you had, has been resolved. So that's really a sanctuary city in a nutshell. What they're saying is that we're not going to notify immigration, ICE, about individuals who are detained, individuals who call up, individuals the police officer may have come into contact with who are undocumented. We're not going to refer you to immigration authorities. That's all that means. So that's to answer that aspect, the sanctuary cities, that's really what it is. Catch and release is a different thing. It means that if immigration official catch you, for example, you're in the United States and your authorized stay has expired, and somehow an immigration officer come in contact with you, or you have a criminal conviction and you know that's a deportable offense, etc. If they come in contact with you, they should detain you and they should take you into custody and detain you and not release you. That's really what the catch and release is. Before that policy by Trump, the prior administration look at individuals and prioritize. So if you maybe were a dangerous criminal, you had a domestic violence charge, you had maybe a DUI, which is what we call a drunk driving charge, etc. Offenses that they look at you as a danger to the community, then they would detain you. But other individuals who may have overstayed, maybe driving without license, they will not detain you. So you would be released. That does not mean the fact that you were not detained does not mean you were not placed in removal. They'll still place you in removal, give you an NTA, notice to appear, but you'll have to appear in immigration court, voluntarily. You're not detained. If you're detained, then they'll take you to your hearing, etc. And so that's really what's the catch and release. They come in contact with you. They know you committed an immigration infraction. It's a minor infraction. We're not going to bother you. We're not going to detain you. We could give you an NTA. You'll appear in immigration court when you get the hearing date. The majority of individuals never do, and that's always a bad idea to not do that. I'd say you're given an NTA, which is a notice to appear in immigration court. When you get the notice to appear, you should really contact an immigration attorney, and you should do that immediately upon receiving, really, the NTA. Now, getting to the crux of the matter. Remember, once you're in deportation, and I know asylum cannot be discussed fully without talking about deportation, because, as I said, the second phase, if the asylum office deny your asylum application, they're going to place you in removal, which is deportation. And the term today's term is removal. It used to be deportation, but we call it removal. And you have some rights. Now, when you're before the immigration judge, you could apply for any relief that is available to you on the immigration law. You don't have to confine to asylum. It could be any relief. So, if you have a lawyer, the lawyer may look through, see if you have relief. Maybe you have an old immigrant petition that was filed for you. It is current. Maybe you could adjust your status. You could apply for that. You may not be eligible for asylum. What about withholding? What about deferral of removal? What about trying to get, if you've been in the U.S. for more than 10 years, and we could show exceptional hardship to a qualifying relative? Maybe you could apply for a green card before the immigration judge. But there are a process, and there are avenues, and we call them relief, that you may be available for. Now, remember, in our last video, we talk about removal of condition for individuals who have the 2-year green card, and that if that is denied, they place you in removal before the immigration judge, who would review the denial and could order you, either grant you the 10-year green card or order you deported. It's the same. Most immigration matters end up in removal some way, somehow. You could apply for adjustment of status, and your application for adjustment of status is denied. Now, a lot of people get that letter saying you have no grounds to remain in the country. You could apply, will be placed in you in removal, and then you could apply for whatever relief before the immigration judge. So, remember, applying for immigration benefit, if it's denied, it could end up before the immigration judge. Some cases are priority cases, some are not. So for individuals who are denied, there's no overstay. They may be fined for a while if they were overstays. Maybe a couple of years they may have some issues. And you could file to adjust your status as many times as you want. You could have to try to overcome whatever grounds of the initial denial. But a lot of individuals in the U.S., You're always going to stand a better chance to get what you want or to understand how to proceed under immigration law if you have proper help. And it's always amazing how many individuals do not really seek proper help. It could be a function of economics, and I want to understand that. Obviously, that could be a big thing for individuals who come into the country, maybe do not know the system, do not know the process, and trying to make it, trying to see how they could better their lives here. Obviously, having a lawyer is expensive, but sometimes it is necessary. And I wouldn't say sometimes, maybe I should strike that and say it is necessary. For certain cases, it is absolutely necessary, and that you should never file anything to immigration if you do not know what you're filing and the consequence for not getting it right. You should not. Information is the key. In today's age of technology, we have information about everything everywhere. And sometimes it's just a simple consultation with a lawyer to put you on the right track, and that you should never skip that. And the consultation is not that expensive. I know when we talk about immigration, there are a lot of individuals parading as immigration attorneys. And it even happened to me, as some of you may know, my Facebook page have been copied by other individuals, and they changed the telephone number. And for example, the latest one is a new immigration page at Peter Low Black International with a different telephone number from me, different websites and all of those. But they have my photos and everything that I post on my page. They placed it there too. So you call, you may think that's Peter Low Black you're coming to, but it's not. So in immigration, we have a lot of fakes. So you always got to know who you're dealing with. It's absolutely important that you know who you're dealing with. I would take everything I use with a grain of salt, and I know your friends and family, they all mean well. They all try to help you out sometimes, but that may not be the best advice or the best person you may need to go to for your situation. But it's incumbent upon you to do your own homework too, because it's your life. You understand? And no two immigration cases are the same. It may be two individuals applying for asylum. One may get it, one may not. It all depends on the facts and circumstances of who represent that individuals. But I could never forget, I had those similar situation with 5 individuals who got into problems, and we represented 2 of them. The 3 others had different lawyers. The 2 that I represented got what they wanted. 1 of the 3 got what they wanted, but 2 did not. So everyone have different, they were all applying for the same thing, but it's the facts and circumstance and how you prepare your case. I'm not saying that having a lawyer means you're going to win a matter or you're going to get it. It's the facts of the case. But at least you will understand, that the difficulties and what you need to overcome. There are certain individuals who are in the U.S. and you have been in the U.S. for years, but you may never get no green card. If you have certain convictions, it's not going to go away. The law is clear. It's stated here. So you could have lawyers upon lawyers, but if you have a drug trafficking offense, and that's what it is, and it has been for years, it's not going to change. You're not going to get a green card. If you made a false claim to U.S. citizenship, and it's clear and there's no argument to defeat the fact that it was a false claim, then it's going to be there. I did have a client, a recent client, from Nigeria, who came here with a U.S. passport. Someone gave him a U.S. passport. But the good thing that he did when he arrived in Orlando, I know he claimed that he went to school in Orlando, but they asked him what was the high school he went to, and he didn't know the high school. But then he asked for asylum immediately. On the surface, it was a false claim to citizenship, yes. But the argument one could make to defeat those things is that the person was coming in, and the only way they could come in to apply for asylum is a U.S. passport. No aircraft was going to board him without either a green card, a visa, or a passport. But the intent was not to claim citizenship, but was just to present himself for asylum. We did get him asylum, and he was able to get his status adjusted, But I say this to emphasize the importance of developing your case and having representation in immigration before USCIS and the immigration court. That really going to take an interest to develop your case and to present it in the best light within the confines of the law. No lawyer is going to lie. No lawyer is going to present false document to the court. If the lawyer knows that's false document, I certainly would not do that. So it is important to understand those things. I have another asylum. I get asylum case. I'm in Nigeria. Some people stay. I'm in Kenya. I'm in Jamaica. I need to come in. I'm homosexual. It's not allowed in my country. People will fight me. Can I apply for asylum to come to America? You could only apply for asylum if you're in America. You have to be on American territory to apply. So, that's the crux of the matter. You have to present yourself at the border. And individuals come in from all over the world. Some will be detained, as I said, some will not be detained. It depends on the circumstance. It depends on maybe your credible fear interview, what happened, what you go through, how you're able to relate your case, what documentation you may have. So all of those are important. I have a question for Maha. She asks, if me and my husband are not working in the U.S. and we are not depending on the system to live, applying for citizenship, we are resident for 5 years now. Now, if you have a green card, you're a legal permanent resident for 5 years. You're eligible to apply for naturalization provided you meet the other requirements. You do not necessarily have to work. If you're self-employed, you're self-employed. If you're independently wealthy, you're independently wealthy. That's fine. That's not an issue. There's no law that says you must be employed in the United States. You could be a consultant, and most of your employment and your income come from outside the country from your travels. As long as you meet the requirement, obviously there's a residency requirement that you must satisfy. So more than half the 5 years got to be in the United States. And you cannot have any trips outside for more than a year. Certain things that would break your residency. So if you meet the requirements, you could apply for naturalization. I would say call my office or an immigration attorney of your choice. My office number is 407-295-0099. But applying for naturalization, if you meet the requirements, you can. There's no law that says you must be employed. Obviously, you have to be a person of good moral character. So your income cannot be obtained from illegal activities. So as long as you do not fall within the exceptions, then you'll be fine. It's not going to be a problem. And remember, the individuals could apply for naturalization. There's some of them 5 years after getting the green card, some 3 years, and the 3 years apply to individuals who obtain the green card through marriage to a U.S. citizen, and they continue to be married to that U.S. citizen. They would be able to apply for adjustment 3 years. And you could always do it 90 days before the 3-year anniversary or 90 days before the 5-year anniversary. Now, individuals want me to talk to them about giving birth in the U.S. I will address that. And on my page, I have a number of posts as it relates to giving birth. But you need to understand one thing. You have a tourist visa. A tourist visa is issued to individuals to come to visit for pleasure. That's the purpose. If they come to visit for pleasure or to come on a business trip, to attend a conference, a seminar, to have meetings, etc. Not to give birth. It's not. If you go to the embassy and say, I want a visa, my purpose is to give birth, you're not going to get the visa. You will be denied. So If you come here to give birth, you're lying when you enter the country. Remember, the visa purpose is for an airline to take you to the US. That's all it is. It does not guarantee your admission into the country. When you come into the country, you go to the counter, the CBP officer is there, you hand him your passport, you hand him with the visa, you are applying to be admitted into the US. But when you hand in a tourist visa, what you're saying that I am coming here to visit for pleasure, and you have a return ticket that's noted already. I'm coming here to visit for pleasure, to stay for X amount of days. So you would be lying when you do that. Because if you tell that officer you come to give birth, he's going to send you back and cancel your visa. So that's the whole crux of giving birth. And after you give birth here, and either the CBP officer later find out on your next trip, or the embassy comes, the consular officer of the embassy find out that you give birth in the US, then your visa is in jeopardy. You're always going to have problems. You know, it will be cancelled generally, because first you lie. When you came here, you misuse your visa. So that's the whole issue. And worse, a lot of individuals, remember in the US, you have to pay for medical care. So if you're not a resident of the US, generally, you're not eligible for any public assistance. So a lot of individuals come here, they give birth, but they're here, and individuals apply for Medicaid on their behalf, and it's called welfare fraud. So when the government pay for your birth, they look at you paying, you committed fraud. Obviously, the embassy want the government to recoup its money. They'll tell you have to pay the birth. You got to pay them. Contact the state where you give birth and pay them back the Medicaid. You committed welfare fraud. And a number of individuals believe if I go and pay it back, I'm going to get a visa, but you're never going to get a visa. But you should pay it back. So that's the whole crux as it relates to coming to give birth. Individuals do it, and they think that they can, and they think but immigration rules and regulation is clear. It's what you're declaring and the intent. Now, and again, a number of individuals always believe that if you have US citizen children, you automatically have some benefits in the United States. There's none. You violating your visa or voluntarily coming here, I mean, you just think of it for a second. You voluntarily come to a place and you've gave birth to that place. And let's say the country give the child, because the child is born there, citizenship. You figure that's going to confer some benefit on you? No, it does not. They never consider that. So no, there's no benefit conferred to a parent who give birth into the United States. You're just giving birth. When your child is 21, they could petition for you. You know, provided that they reside in the United States, they could file an immigrant petition for you. But before that, there's no benefit. It's a voluntary act on your part to come here and give birth. A lot of people secret their pregnancy, they hide it, they camouflage it, because that's always raised an issue at inspection when they arrive in the United States. You know, the officer saying, are you going to give birth? How far you are, what was the purpose? What's the purpose of the trip? But there's no benefit whatsoever for the parent simply by coming here, overstaying, or by just giving birth in the country. So now, remember, in the connection of those giving birth in the US, once your visa is cancelled, there's little hope of getting that visa back. You know, once it's cancelled, there's little hope. Some people figure, oh, I could get it back. No, you can't. One thing you need to realize, especially when it comes to non-immigrant visas, these are at the complete discretion of the consular officer. There is no law to appeal. The decision is made. It is a final decision. You could reapply and reapply as many times as you want, but the consular officer is going to make the determination, and if you have been denied for violating your visa, you're generally not going to get another visa. You know, if you come to work and you work in the US, or you admit you came to work and you have a tourist visa, you're not going to get back another tourist visa for a very, very long time, because no other officer is going to trust you with a tourist visa. Tourist visa, it's the B1, B2 visa. It's a visitor for pleasure, a visitor for business purpose. That's the sole purpose. All visas issued are for specific purpose, and you have to honor the purpose of the visa. So we start off with asylum, which, and I want to recap, remember, individuals coming to the US could apply for asylum if you have suffered past persecution in your country, or you have a well-founded fear of future persecution in your country. But the persecution must be based on race, religion, national origin, or membership in a particular social group. The particular social group is very broad. It could be women that are beaten by their husband who suffer domestic violence. It could be wives of police officers who abuse their kids. It could be gang members. That's the broadest group where individuals claim asylum under. You could only apply in the US. It's best, if you're coming for asylum, to apply at the port of entry. You will be detained, and the detention could be lengthy. Some individuals may not be as long, but it could be lengthy. It could be throughout the process. If you happen to be in the US, you could apply for asylum a year from your arrival. Anything after your arrival, more than a year, is not, except if you're applying, you could show why you're applying late, or if there have been a change in your country. If there have been a change in your country or circumstance, then yes, a year from the change is fine. It's best you'll go through an asylum officer who make the initial determination, a well-founded fear. That officer could grant asylum or not, refer you to an immigration judge. When they refer you to an immigration judge, that means you're in removal proceeding. You'll issue a notice to appear, which is an NTA that's outlined why they want to deport you. The immigration judge then, could review your asylum application. You could file for asylum before that immigration judge. Consistency in your asylum papers and testimony is absolutely important. It just matters that you should have immigration attorney on. You should consult an immigration attorney, retain an immigration attorney to handle this matter. Documentation is key, consistency is key, effective representation is key. It was a pleasure talking to you this Saturday. This is immigration attorney Peter Loblack from Peter Loblack Law Firm. My office telephone number is 407-295-0099. Have a wonderful weekend, and we shall talk the next time.